It is something of a commonplace to note that Rome, in its art, architecture, sculpture, philosophy, much of its literature, is beholden to Greek originals. So much in classical Rome is derived from older Hellenic and Hellenistic forms that even where originals might be claimed for Rome, legend often inserts Hellenic roots. It was said by the ancients that even Rome's 12 tables, the famous 12 tables on which were inscribed the laws of Rome, were created only after a Roman detachment had gone to Athens to take counsel with no less than Solon. Surely Roman law has debts to Greek law and Greek philosophy of law. The Greeks, after all, were a litigious people who kept the law courts busy all the time. And ancient Greek law is highly developed. Nonetheless, if there is a contribution that the Roman world made to civilization and the history of ideas, where, notwithstanding to the contrary, some debt or other to Greeks has to be acknowledged, that core contribution would be Roman law. In its development, precision, refinement, and especially promulgation, there isn't anything in the ancient world that can hold a candle to it. It is one of the great cultural achievements of any people, and to the extent that all of Western civilization is centrally indebted to a life of ordered liberty under the rule of law, this becomes one of the great contributions to civilization in all its forms and varieties. Not enough can be said in praise of this Roman contribution to civic, civilized, and alas, civilizing life. Now, one of the critics of Stoicism, as I mentioned, was Cicero. I described him as eclectic in his philosophy. But eclectic though he was quite at home with Stoic teaching. He is an important figure in Roman philosophy and politics, and one of the greatest essayists that the Latin language would ever produce. One of his most influential essays was one on the laws, De Legibus. It's in this essay that Cicero comes to grips with the questions, what is the essence of law? What forms of law are there? How should law be understood? What is it that law matches up with in us? Now, Cicero makes an important distinction between law as it operates differently in different jurisdictions, in different civic communities, and law as it seems to function everywhere. Some rules and laws vary widely throughout the known world. In Cicero's time, going to Carthage or to Egypt, to Alexandria, to Rome, to Athens, any number of statutory variations can be found in making journeys of that sort. The type of law that displays this variation is what Cicero refers to as the jus civile, what we would translate as civil law, but in the sense of jurisdictional law. So, let's say one is a Carthaginian in Rome for the day and happens to park a chariot in front of the courthouse. The meter expires, the alien visitor not having put enough coins in. Said alien is now brought before the court and answers the charge this way. Well, Your Honor, I'm a Carthaginian, and where I come from, you can leave your chariot anywhere you like. It is found in the court that he has never visited Rome before, was not aware of the particular restrictions. So these facts would constitute mitigating circumstances. Now, I'm not quite sure what the fine would be, or if it would be reduced, but at least it would make sense for the magistrate to say, in a case like this, a Carthaginian, you are a strange people, aren't you? And you've never been here in Rome before, have you? And where you come from, you can leave these horses anywhere you like. You can bring them into your houses and all that. Yes, I see. Well, all right, just don't do it again. And the best bet for you anyway is, when in Rome, do as the Romans do. Now that probably would be the beginning, middle, and end of the matter. Cicero considers, however, an entirely different understanding in the matter of laws and punishments. He observes that in every known community, there are certain precepts that are honored without exception. These precepts seem to be universal, understood and adopted precepts regarding violent and lethal assaults on the innocent, precepts involving the appropriation of what is recognized to be the property of another, precepts regarding what kinds of transactions remain valid even in the face of fraud and deception, and lies and libels, how fraud and deception and lies can negate negotiations, negate settled agreements, matters of that sort. Now, with respect to offenses of this kind, Cicero will reason, as Aristotle did in the Politics. Aristotle, too, notes that there are jurisdictional differences when it comes to law. And although there are variations from jurisdiction to jurisdiction, with respect to some legal precepts, some core principles of equity, Aristotle declares these are, quote, universal and everywhere the same. Now, when Aristotle next sets out to illustrate the universality of core principles of equity, whom does he turn to? He turns to Antigone, standing before King Creon. And what is Antigone saying to Creon? In so many words, she's saying, as I indicated in an earlier lecture, that a sister will bury the body of her dead brother is grounded in our very nature, in what is more fundamental than kingship itself, in something universally understood. She actually says of her conduct that she would not be embarrassed to appear before the gods saying, I have done this, before the gods themselves. Now, Aristotle turns to Sophocles' Antigone to remind his Greek audience, his Athenian students, what he means by a universal precept, a universal principle of equity. There are certain notions of fairness that virtually express our rationality. This is not something that's going to vary from place to place. That is, find an entity in whom this principle is not operative, and you've got an entity that might be human in name only, or in face only, or in body only, but is utterly lacking in one of the defining attributes of a human being, namely a rational recognition that certain principles are determinative. Now, Cicero gives a label to this, referring to it as the jus gentium. This is the law of nations. Gens, gentis. Gens is a tribe, a clan, a nation. Gentis is the genitive. Jus gentium, then. Gentium is the genitive plural. So the jus gentium is the law of nations, the law of a people, and the law of peoples. Well, of course, the question that arises then is how the jus gentium is to be understood. Cicero already recognizes that it cannot be explained by assuming that tribe A somehow taught this to tribe B, which then taught it to tribe C, etc., so it becomes the jus gentium by imitation. This can't be because the jus gentium is operative in places that have been utterly unaffected by other places. So, to explain this, Cicero develops an explanation. He doesn't label it. The label for it will be assigned in the 1st and 2nd centuries AD. But the explanation that Cicero offers for the jus gentium is that it arises from the very nature of human nature itself. It reflects something that is essential to a rational being, essentially known by a rational being. And as I say, by the end of the 1st century AD, this will be referred to as the jus naturale, the natural law. And indeed, Cicero, as with Aristotle before him, as with Sophocles before both of them, and to some extent Homer before all of them, is laying the foundations for one of the most developed theories in philosophy of law, the theory of natural law. It will, of course, become famously developed and promulgated by Thomas Aquinas. Now, to this day, there are those who believe that natural law theory is some Roman Catholic conspiracy. So it is useful to remind such people that Aristotle was not a very good Christian at all, and Socrates, in this respect, was even worse. Well, let us produce our fictional Carthaginian again, this time coming to Athens, where it's not a matter of putting his chariot in front of the courthouse. Now he robs the bank. He kills the teller, and he gets away in a getaway chariot, taking on an assumed name. Later apprehended, he appears before the magistrate, and let's say he says this now. Well, Your Honor, I'm from Carthage, and we're a fairly wild bunch there, and I didn't realize that in Rome you're not supposed to commit murder, rob, cause mayhem, etc. Well now, the magistrate is likely to say something like this. Ignorantia legis neminem excusat. Ignorance of the law excuses no one. Now, we've seen that ignorance of traffic ordinances did constitute grounds of excuse. So what is the magistrate getting at when he says ignorance of the law excuses no one? In this, he reflects on an aspect of the rule of law itself that is more fundamental than statutes and local ordinances. He is affirming those principles, those core understandings possessed by anyone who is actually fit for the rule of law. Not to know this much is actually to be one outside the rule of law. It is to be an unnatural or undeveloped or defective kind of being, part of no gains at all, part of no nation, community at all. Roman law, administrative law, successfully permitted Rome to administer the world, to administer the known world, and to do so for centuries. One of the most poignant documents that antiquity turns up appears when the Visigoths have sacked Rome and taken it over in the 5th century AD. And one of the first items promulgated by the leaders of the Visigoths is titled what? Lex Romana Visigothorum, the Roman law of the Visigoths. Poignant in what way? Here we find Gothic princes, Gothic leaders, coming on horseback from strange places and with odd customs to lay siege on the center of Western civilization. Here they are breaking up China, causing a general ruckus. But then what? They understand something in a way that validates the notion of the jus naturale. They understand that what made Rome great just was that institution of law, that set of rational precepts that rendered life predictable, that let people know their obligations and their rights and their duties. It was a law for settling disputes without force, without violence, a system that revered the citizen in the sense of holding that citizen responsible to the rule of law as a rational being, special in the cosmos, the occupant of a singularly unique family within a common oikos. So the Lex Romana Visigothorum is just added evidence of the fact that wherever you're coming from in the world, you're recognized in Rome not only in terms of military standing. The barbarian hordes, the Ostrogoths, the Visigoths, the Vandals, and the like, proved to be a match for the might of Rome. And Rome was no longer the once unopposable force by the 5th century AD. It was readily opposable long before that. When we say that Rome fell in 476 AD, one wants to smile and say, was that a Thursday afternoon or a Friday morning? Rome had been falling, getting up, and falling again for decades, sacked time and again. Constantine in 300 moved the center of the empire to the east, leaving the eternal city as something of a cultural memento. But what was durable in Roman civilization was neither the military nor the city itself, but the law of Rome, the administrative machinery, governed by principle and administered by legally trained and sophisticated and subtle minds. It is worth noting, by the way, that any number of Roman emperors were lawyers and participated regularly in the revision and drafting of law. And an emperor who was just too far outside an understanding of law would have been regarded as bizarre by his contemporaries and indeed dangerous to boot. Long after the so-called fall of Rome, we have the Institutes of Justinian, promulgated in the 6th century. The Institutes of Justinian was the work of Tribonian and his colleagues, commissioned by the emperor to reduce to a convenient formula the institutes or elements of Roman law, to put it in a form where it could be taught. Now, this is now a greatly extended and variegated empire, still committed where possible to life according to the rule of law. And so the institutes here are being put together at the command of Justinian and will provide the framework for political life, in fact, for centuries to come. Now, what do we find when we consult the institutes? After a quite brief introductory paragraph, this is the first thing we confront when we read the Institutes of Justinian. The law of nature is a law instilled by nature in all creatures. Could anything be clearer? Could Stoicism have said it any better? The law of nature is a law instilled by nature in all creatures. It's not merely for mankind, but for all creatures of the sky, earth, and sea. All peoples with laws and customs apply law, which is partly theirs alone and partly shared by all mankind. The law which natural reason makes for all mankind is called the law of all peoples, the jus gentium. So, here we are in the 6th century, and it might just as well have been Cicero who wrote this. And if he wrote it, and if he had been graded by Aristotle, Aristotle would have given him an A. What is taken for granted is that nature does nothing without a purpose, that there is an order and reasonableness to it, and that human affairs are to be governed by the same rationality, the same orderliness, the same logos. Now consider what is meant in the Institutes by nature fitting out all creatures with law. The animal kingdom does instinctually what's required for its own survival and flourishing. The animal kingdom does not require years of instruction, nor is the infant taught to take nourishment at the breast. The baby behaves instinctually, fitted out by nature with a rule that works to the advantage of life and flourishing. Peoples also are fitted out by nature with certain intuitive understandings essential to a life that will be a flourishing, coherent, culturally continuing life. And how does nature do this? By making us aware, at the most fundamental and intuitive level, of core precepts of equity, as in Antigone's defense. So the jus gentium now is a unifying principle capable of smoothing out differences of culture and custom, capable of providing at least the possibility of a shared civic life. A few remarks are called for on the status of the jus naturale in what is a multicultural world. To lecture at the beginning of the 21st century must give one pause when speaking about something that is allegedly universally distributed throughout the human race. But what Roman law reduced to written form was understood to reach all who qualify as rational beings. These Romans had traveled widely and had witnessed as much by way of cultural diversity as today's residents of, say, Berkeley, California. They were up in Britain doing battle with Celts. They were in the foothills of the Caucasus. They occupied Egypt. They overtook the Greek-speaking world. They tried to control the ancient Hebrews with mixed results. If anybody knew about multicultural contexts, it was Rome. Far more than we do, I submit, because their contact was more regular and indeed more dangerous. Wouldn't that have been enough to tell these Roman jurists that the whole notion of jus gentium and jus naturale is a miscast notion? It's just bad cultural anthropology. Well, get out there and conduct your polls and samples and sit down with these people and come to terms with the fact that given their religion, diet, local customs, historic practices, well, for goodness sake, they've got a radically different sense of law than anybody brought up in Rome or Athens is going to have. You know, there is a face of multiculturalism, and I think one always has to be a bit tentative before adopting isms that really constitute an obstacle to toleration, affiliation, and friendship. There's a side of multiculturalism that casts certain people as so fundamentally different from other people that the two can hardly make sense to each other. This is something Stoicism rejected. It's something Aristotle, on principles of equity, rejects. It's something Plato rejects. It's something Homer, in his deep humanity, rejects. The sympathy and respect for all the warring parties jumps off every line of Iliad. The ancient world, for all its elitism, recognizes a fundamental unifying force according to which we have a shared psychology, a shared spirituality, and a common humanity. What the law in its developed form must appeal to is just that common humanity. Now, find a creature that cannot be appealed to at that level. And the best explanation is not that the creature is the product of a different culture. The best explanation is that the creature is in some sense incomplete in its humanity, outside the natural order of humanity. What kind of creature would that be? It would be one the law would regard as insane, profoundly retarded, perhaps just too young, not there yet, not up to it, stuporous, in a drug-induced state, or having sustained a traumatic injury that rendered him insensate or incapable of cognitive processing. But find an adult, mature, healthy human being anywhere and everywhere in the world, and that human being, in virtue of being a rational being, will recognize certain precepts as unchallengeable. The truth of them will be evident, and were it otherwise, it would be impossible even to engage in trade, even to summon sufficient credulity to enter into a transaction, to believe that the party on the other side will fulfill the terms of the agreement. It would become impossible even to explain why punishment is being imposed for certain transgressions, or why rewards are being given. In order for reward and punishment and the rule of law to make any sense at all, one must be dealing with someone who recognizes himself as having certain agentic powers, the ability to do or forbear from doing certain things, and to do or forbear from doing certain things on the basis of a principle, which when asserted might result in a reward, and when violated might result in a punishment. There is no tribe so primitive, no people so backward, no time so remote, that the operation of these principles is not evident on first inspection. John Locke, centuries later, will say that the madman reasons rightly from wrong premises. And we might say that to that extent, there will always be a kind of cultural influence on how precepts of law and fundamental concepts of justice operate in a given place. There might be certain religious premises, for example. There might be premises that, well, on one cultural view, are highly superstitious or mystical. But given these premises, the question then becomes, are the conclusions that follow logically drawn from those premises? So I don't want to argue that the cultural variations we observe are merely artificial entries that obscure what is indeed a homogeneity. No, there is a great heterogeneity from culture to culture. Rome was persuaded that that heterogeneity did not extend to the level of rationality itself, and therefore that all people, wherever they were from, whatever they believed, and whatever their customary practices might be, were fit for the rule of law and could be brought up to be worthy of the rule of law. Now, after Alaric had sacked the city of Rome, a number of Romans came back to what was now their defeated city, I guess to see what was left of the place and how the pieces might be put back together. In the 5th century AD, Rutilius Nematiantus came back to his sacked city, and he would write these lines about his beloved city of Rome. Quote, "Thou hast made of alien realms one fatherland. The lawless found their gain beneath thy sway. Sharing thy laws with them, thou hast subdued. Thou hast made a city of the once wide world." Close quote. It was the promulgation of Roman law that would make a city of the once wide world and create a coherent Western civilization. Now, I want to return to the size of the debt to Roman law. First, I want to point out that with respect to the institutes, the Code Justinian, and its promulgation, we will find in Elizabethan England the most eminent legal authorities still citing the Justinian institutes. We will find in the history of British common law, in American constitutional law, in the European Code Napoleon, in all of these diverse Western civilization expressions of lawfulness, the debts to Rome are apparent. Legal education today, even under the banner of legal realism, even under the banner of a certain sociology of law, still retains certain core assumptions about what is necessary for a being to be fit for the rule of law. Our conceptions of justice, of liberty, the dignity of the individual, at least when the individual appears before the bar of justice, these are developments out of a Greek philosophical foundation, no doubt, but these are developments by Roman lawyers, by Roman emperors as lawyers, reducing what otherwise is the flotsam and chaos of daily life and daily strife to an orderly process in which the disinterested judge can weigh evidence, can examine claimants, and can arrive at a judgment that is conformable not to the popular will, but conformable to the principles of reason and reasonableness. There are two ways of settling disputes, aren't there? With swords and with judgment. And the only reason the latter works at all is that no matter how intensely in conflict disputants are, they are disputants secondarily and rational beings first. And each of them finally can be prevailed upon at the level of rationality to accept a judgment understood to be fair because it is conformable to reason itself, which is the manner in which the law expresses itself in the civil domain. So, there is no gilding the lily in saying that what we are pleased to call Western civilization, so deeply indebted to ancient Greek sources in art and architecture, in literature, especially in philosophy, that this Western civilization itself is utterly unimaginable in the absence of those developments of law and institutions of law created and to a very considerable extent perfected in ancient Rome by nameable persons self-conscious about the relationship between a decent and flourishing form of life and a rule of law defensible in the arena of reason.